New at 10, when an officer is involved in the death of another person, what happens next falls on the shoulders of prosecutors. I-Team reporter Kat Reed is lifting the veil on the process of charging a police officer, with insight from prosecutors on both sides of the state line.
Lady Justice is always depicted this way.
She has a blindfold on because everyone should be treated the same.
That includes those tasked with protecting us. When an officer is involved in the death of another person, it's typically up to our prosecutors to decide if criminal charges should follow. In Johnson County, Kansas, and Jackson County, Missouri, that process starts at the crime scene.
Since I've taken office, my chief deputy has been the one who gets called out to the scene. I usually have my chief investigator from my office also go out on the team.
We view those scenes as special and different, and that they need to be managed as special and different.
When there's an excessive force case in Johnson County, an officer-involved shooting investigative team leads the probe. Those investigators come from outside agencies.
Quite honestly, it gives the public a sense of security knowing that it's not their buddies investigating their own.
In Jackson County, practices vary. A recent example, the Missouri Highway Patrol was called in to investigate after an off-duty Raytown police officer shot and killed an armed man at a Walmart. Meanwhile, KCPD had been investigating its own incidents, but Mayor Quinton Lucas announced Thursday all officer-involved shootings and certain use of force incidents will be reviewed by outside agencies.
In officer-involved cases, they do take additional time because officers have certain provisions through their union contracts that we must abide by. So officers get additional time before they make a statement.
Charges depend on intent.
So we have reckless conduct, meaning that the person was reckless in committing the crime of murder, and then you have intentional conduct. So if the person intends to kill another person, and then you have premeditated, which is I planned on killing an individual.
House says deciding on charges takes time because Kansas has 10 different statutes dealing with use of force and self-defense.
There are several Supreme Court decisions that say that if you don't look at the person's right to defend themselves before arrest, it will result in the dismissal of the case, flat out.
In a recent high-profile case, Howe declined to bring charges against the officer responsible for killing an Overland Park teen in January 2018. His office decided the officer was justified in opening fire because he feared for his life. Prosecutors can decide to bring charges, or they can take their evidence to a grand jury who decides whether or not to return an indictment. That grand jury process can take longer.
The other thing is a grand jury is secret. By statute, you cannot discuss what goes on in a grand jury.
Prosecutors should not hide behind a grand jury, and they also should only use it when it's the only path they have forward.
Like when the investigating agency doesn't submit a probable cause affidavit to the prosecutor. It's why a grand jury was used to bring charges against 2 KCPD officers involved in the May 2019 arrest of Breonna Hill. Regardless of how charges are brought, it's a unique position for prosecutors, going to court against officers who normally solve crimes, not commit them.
It's not something we like to do, but one of the things that as a prosecutor you learn that you have to do is you have to take the emotion out of it. Our decisions should be objectively made based on the facts and the law.
Because justice is supposed to be blind. I'm I-Team reporter Kat Reed, 41 Action News.
KCPD Chief Rick Smith says his department found no probable cause that the officers involved in Hill's arrest broke the law. That's why there was no probable cause affidavit sent to the prosecutor's office. 41 Action News reached out to Wyandotte County Prosecutor Mark Dupree. He was not available.